What is subordination? In commercial real estate leases, subordination, in a commercial lease context, is a legal mechanism that alters the priority of certain interests in the property. It is most commonly applied to adjust the relative rank between a tenant's leasehold interest and a lender's mortgage or deed of trust, encumbrance, against the landlord's fee interest in the property. In simple terms, subordination dictates which interest, the lease or the mortgage, will be considered superior or senior, and which will be considered inferior or junior, in the event of foreclosure or other adverse action. Historically, the priority of these interests is generally determined by the first in time, first in right rule, meaning the interest recorded first typically holds the superior position. However, through contractual agreements, this priority can be reversed or modified, which is the primary function of a subordination, non-disturbance, and attornment agreement. From a commercial lender's perspective, securing the superior position is critical for risk mitigation. When a lender provides financing to a landlord, owner, to purchase or refinance a property, they require that their mortgage lien be prioritized over all subsequent or existing interests, including tenant leases. If a lease were to remain superior to the mortgage, a foreclosure by the lender would not extinguish the tenant's rights, and the lender would be bound by the existing lease terms, potentially including below-market rents or undesirable clauses. By requiring the tenant to formally subordinate their lease, the lender ensures that, upon foreclosure, they can elect to terminate the subordinate lease to install a new, market-rate tenancy if they choose, thus preserving the property's value and their collateral position. While subordination is necessary for the lender, it poses a significant risk to the tenant, as the superior lender could terminate the lease upon foreclosure, forcing the tenant to vacate and lose their investment in leasehold improvements. To address this imbalance, the concepts of non-disturbance and attornment are introduced, creating the subordination, non-disturbance, and attornment agreement. Non-disturbance is the lender's promise that if they foreclose on the landlord, they will not terminate the tenant's lease, provided the tenant is not in default. Attornment is the tenant's promise that they will recognize the foreclosing lender, or subsequent purchaser, as the new landlord and continue to pay rent to them under the existing lease terms. Together, these clauses create a balanced exchange. The tenant subordinates their lease, protecting the lender's collateral, in exchange for the lender's guarantee that the tenancy will be preserved, protecting the tenant's business continuity. The negotiation of a subordination, non-disturbance, and attornment agreement is often a crucial precondition for a large commercial tenant to execute a lease, and for a lender to close financing on a property with existing tenancies. For sophisticated tenants, securing a favorable subordination, non-disturbance, and attornment agreement with non-disturbance is non-negotiable, as they cannot risk the substantial cost of relocation and loss of business caused by foreclosure. Furthermore, the negotiation will often address specific details regarding what constitutes a landlord default, the scope of the new landlord's liability, such as, they typically are not responsible for past defaults or tenant improvement allowances, and the specific conditions under which the non-disturbance promise is activated. Ultimately, the subordination, non-disturbance, and attornment agreement transforms the potentially destructive legal outcome of subordination into a manageable, mutually beneficial arrangement that serves the commercial interests of all three parties, tenant, landlord, and lender. To learn more about our commercial leasing legal practice, visit our website, or contact our law firm to schedule a confidential consultation. Thank you.